Hello and welcome to the class. Today we shall discuss about the rights of indigenous people under the UN Human Rights Instruments. The concept of human rights has been widely used by different actors from different perspectives at different point of time. However, there is no consensus on the definition. The concept is continuously evolving along with the debate of what constitutes human rights. The most accepted definition is that of United Nations, that is UN, which defines human rights are those rights which are inherited in our nature and without which we cannot live as human beings. The international human rights instruments were the outcome of various human rights movements around the world. It can be reflected through various treaties, conventions, declarations which we can club as 1. Civil and political rights, 2. Economic, social and cultural rights, and 3. Solidarity rights. Some of the significant instruments for human rights are 1. Magna Carta, year 1215, 2. Petitions of Rights, year 1628, 3. Habeas Corpus Act, year 1679, 4. English Bill of Rights, year 1689, 5. United States Declaration of Independence, year 1776, and 6. French Declaration of Rights of Man and Citizen, year 1789. However, these instruments were not mostly universal in character as it was confined to their respective countries or region. The first document that was universally accepted and later recognized as a customary law was the Universal Declaration of Human Rights, that is UDHR, adopted in the year 1948. It can also be treated as the root of UN human rights instruments. Now let us talk about the UN and human rights. The human rights system of the UN can be broadly classified as charter-based bodies and treaty-based bodies. There is a need to distinguish between these two bodies as these two bodies have different mandate and activities. A. Charter-based bodies. The charter-based organs have broad mandates, including promoting awareness and responding to violations of human rights standards. They are known as charter-based bodies as they were established by resolutions of principal organs of the UN whose authority flows from the UN Charter. These political organs focus on a wide range of issues, and every state is an actual or potential respondent or client. Regardless of its specific treaty obligations, they take action based on majority voting. The current charter-based bodies are the Human Rights Council and Special Procedures. Now let us talk about the Human Rights Council, that is HRC. The Human Rights Council is responsible for strengthening the promotion and protection of human rights around the globe and for addressing situations of human rights violations and making recommendations on them. The Human Rights Council, which replaced the Commission on Human Rights by the General Assembly Resolution 60 by 251 of 15 March 2006, held its first meeting on 19 June 2006. This intergovernmental body, which meets in Geneva 10 weeks a year, is composed of 47 elected UN member states who serve for an initial period of 3 years and cannot be elected for more than 2 consecutive terms. Now coming to the subsidiary bodies of the HRC. The Council adopted its institution building of the United Nations Human Rights Council to guide its work and set up its procedures and mechanisms by the Council Resolution 5/1 of 18 June of 2007. The bodies are, firstly, Universal Periodic Review, that is UPR. The UPR was created through the UN General Assembly on 15 March 2006 by Resolution 60/251, which established the Human Rights Council itself. The UPR is a unique process which involves a review of the human rights records of all UN member states. The UPR is a state-driven process which provides the opportunity for each state to declare what actions they have taken to improve the human rights educations in their countries and to fulfill their human rights obligations. The UPR also includes a sharing of best human rights practices around the globe. Now, next, let us talk about the Human Rights Council Advisory Committee, that is Advisory Committee. The Advisory Committee is established by Council Resolution 5/1 of 18 June 2007. It is an expert body of 18 experts serving in their personal capacity that functions as a think tank for the Council, which provides its expertise and advice on thematic human rights issues. The Advisory Committee supersedes the Subcommission on the Promotion and Protection of Human Rights. The first meeting of the committee was held in August 2008. It meets twice a year for 1 week in February, immediately before the March session of the Council, and for 1 week in August. Thirdly, we shall talk about the complaint procedure. The complaint procedure allows individuals and organizations to bring human rights violations to the attention of the Council. It is part of the institution building of the United Nations Human Rights Council. Its primary responsibility is to address consistent patterns of gross and reliably attested violations of all human rights and all fundamental freedoms occurring in any parts of the world and under any circumstances. The submission is confidential with a view to enhance cooperation with the state concerned, as well as to avoid any potential threat to the individual or organization. As we go ahead with today's discussion, now let us talk about these special procedures. Since the late 1960s, a number of public non-treaty based procedures have been established to examine, monitor, advise and publicly report on human rights situations in specific countries or territories, known as country mandates, or on major phenomena of human rights violations worldwide, known as thematic mandates. They are prominent, independent experts working on a voluntary basis appointed by the Human Rights Council. B. Now let us talk about the treaty-based bodies. Since the adoption of the Universal Declaration of Human Rights in 1948, all UN member states have ratified at least one core international human rights treaty and 80% have ratified 4 or more, that is UN report. They have derived their existence from provisions contained in a specific legal instrument. They hold more narrow mandates and they address a limited audience. For instance, only those countries that have ratified the legal instrument, they take their decision through consensus. The treaty bodies are composed of independent experts and meet to consider state parties' reports as well as individual complaints or communications. They may also publish general comments on human rights topics related to the treaties they oversee. Let us now talk about the core international human rights treaties and its monitoring bodies. There are currently 10 human rights treaty bodies. 9 of these treaty bodies monitor implementation of the core international human rights treaties, while the 10th treaty body, the Subcommittee on Prevention of Torture, established under the optional protocol to the Convention Against Torture, monitors places of detention in states parties to the optional protocol. Firstly, International Covenant on Civil and Political Rights, that is ICCPR. ICCPR was adopted and opened for signature, ratification and accession by General Assembly Resolution 2200A of 16 December 1966. It came into force on 23rd March 1976. It has 53 articles. The monitoring body of ICCPR is the Human Rights Committee. Secondly, International Covenant on Economic, Social and Cultural Rights, that is ICESCR. The International Covenant on Economic, Social and Cultural Rights was adopted and opened for signature, ratification and accession by General Assembly Resolution 2200A of 16 December 1966. It came into force on 3rd January 1976. It has 31 articles. The monitoring body of the treaty is the Committee on Economic, Social and Cultural Rights. Thirdly, International Convention on the Elimination of All Forms of Racial Discrimination. International Convention on the Elimination of All Forms of Racial Discrimination was adopted and opened for signature and ratification by General Assembly Resolution 2106 of 21st December 1965. It came into force on 4 January 1969. It has 25 articles. The monitoring body of the treaty is the Committee on Elimination of Racial Discrimination, that is CERD. The Convention on the Elimination of All Forms of Discrimination Against Women was adopted by the United Nations General Assembly on 18th December 1979. It entered into force on 3rd September 1981. It has 30 articles. The monitoring body of the treaty is the Committee on the Elimination of Discrimination Against Women, that is CEDAW. Fifth, Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment was adopted and opened for signature, ratification and accession by General Assembly Resolution 39/46 of 10th December 1984. It came into force on 26 June 1987. It has 33 articles. The monitoring body of the treaty is the Committee Against Torture, that is CAT. Sixth, optional protocol to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. Optional protocol to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment was adopted on 18th December 2002 by the General Assembly Resolution A/RES/57/199. It came into force on 22nd June 2006. It has 37 articles. The monitoring body of the treaty is the Subcommittee on Prevention of Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, that is SPT. Seventh, Convention on the Rights of the Child. Convention on the Rights of the Child was adopted and opened for signature, ratification and accession by General Assembly Resolution 44/25 of November 1989. It has 54 articles. It came into force on 2nd September 1990. Optional protocol to the Convention on the Rights of the Child on the Sale of Children, Child Prostitution and Child Pornography was adopted and opened for signature, ratification and accession by General Assembly Resolution A/RES/54/263 of 25th May 2000. It came into force on 18 January 2002. It has 17 articles. Optional protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflict was adopted and opened for signature, ratification and accession by General Assembly Resolution A/RES/54/263 of 25th May 2000. It came into force on 12th February 2002. It has 13 articles. A third optional protocol on a communications procedure was approved by the UN General Assembly on 19th December 2011, which will allow individual children to submit complaints regarding specific violations of their rights under the Convention and its first two optional protocols. The protocol opened for signature in February 2012 and will enter into force upon ratification by 10th UN member states. The monitoring body of the treaty and its optional protocol is the Committee on the Rights of the Child, that is CRC. 8th, International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families was adopted by General Assembly Resolution 45/158 of 18 December 1990. It has 93 articles. It came into force on 1st July 2003. The monitoring body of the treaty is the Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families, that is CMW. 9th, Convention on the Rights of Persons with Disabilities. The Convention on the Rights of Persons with Disabilities, that is GA resolution, was adopted by the General Assembly Resolution A/RES/61/106 on 13th December 2006. It has 50 articles. It came into force on 3rd May 2008. 10. International Convention for the Protection of All Persons from Enforced Disappearance. The International Convention for the Protection of All Persons from Enforced Disappearance was adopted by the United Nations General Assembly Resolution A/RES/61/177 on 20th December 2006. It has 45 articles. It came into force on 23rd December 2010. The monitoring body of the treaty is the Committee on Enforced Disappearances, that is CED. Now let us talk about the indigenous peoples and international human rights. The rights of indigenous people under the international human rights treaties are not properly defined, as the definition of indigenous is contentious and debatable. For instance, a working definition was provided rather than an actual definition by Jose R. Martinez Cobo, the Special Rapporteur of the Subcommission on Prevention of Discrimination and Protection of Minorities. While studying the problem of discrimination against indigenous populations, similarly, it is reflected in the process of adopting the Declaration on the Rights of Indigenous Peoples. For instance, even though it was voted by 144 countries, many countries, particularly from Asia, shared their own limitation. However, the charter-based bodies, which has a larger mandate, has put up the issue of indigenous people at the platform of the UN since its inception. They have been continuously involved since the creation of the Commission on Prevention of Discrimination and Protection of Minorities, presently Subcommission on the Promotion and Protection of Human Rights, in the year 1947 till the establishment of creation of expert mechanism on the rights of indigenous people in 2007. Some of the specific instruments on indigenous people's rights are: number 1, the UN Declaration on the Rights of Indigenous Peoples; number 2, ILO Convention number 169 on Indigenous Peoples; number 3, ILO Convention number 107 of 1957 concerning indigenous and tribal populations. After all the discussions we had today, we can conclude that the movement for rights of indigenous peoples have tremendously evolved within the UN human rights system. However, the development of the rights to that of legally binding instrument is yet to be seen, as the UN member states, including India, has not accepted the term indigenous peoples. The charter-based bodies, which has a broader mandate, has been pushing the rights to become a legal binding instrument. The adoption of the UN DRIP is one example. Moreover, indigenous people can claim their specific rights under the treaty-based bodies. So, there is a need to understand the human rights system, as both the charter and treaty-based bodies can strengthen the movement for indigenous rights.